I wanted to raise an issue that I've been studying for some time and increasingly feel more and more strongly about, and I think it may be a difference of opinion. I think Justice Breyer and I have discussed this perhaps in the past, and that's the issue of cameras in the courtroom. Is there any plan in the works to change, to pilot or in any way increase the use of cameras at the Supreme Court?
Yeah, Mr. Munir tells me that the Judicial Conference is currently considering a pilot project that I guess they are favorably disposed towards.
And that would be a pilot project in your courtroom?
No, it wouldn't be in our court.
No. What's that?
It would not. The Judicial Conference does not have to do with our court. It has to do with the lower courts.
Well, let me raise specifically the issue of your courtroom, and I'll share my thoughts on that and be interested to hear your own. I would think probably of any courtroom within the system, appellate courts, both the Courts of Appeals and the Supreme Court, would be probably the best situated for cameras in the sense that you don't have the same kind of jury issues that you might have at the trial court level. You have the ability of the judges to consider whether counsel are playing to the cameras, and I would think particularly at the level of the Supreme Court that counsel would be very circumspect about playing too much to the cameras, given that if that's not the predisposition of the bench, it wouldn't help them in their advocacy. And I think that this is one of the few areas of the public sector that remains free of cameras, and we're still using sketches and audio tapes, which seems anachronistic. And I just think the change is inevitable. But I'd be interested to hear whether you would contemplate a pilot in your own court, or why the dynamic is so much different with an audio tape versus a videotape.
No, the answer is I think I don't know. I know perfectly well what the argument. I think I know fairly well after a long time the arguments for and against. If you bring courtrooms into the cameras into the oral argument, there's a big plus for the court and for the public. I think they'll see that we do our job seriously. We don't always get everything right, but we take it very seriously. People are well prepared. The lawyers are well prepared. The judges are trying to think out problems that are difficult problems. And for the public to see that, I think, would be a plus. So why not do it? The concerns are not, I think, totally the ones you've mentioned, but that's part of it. But the concerns are, if we bring it into our court, we are a symbol. And if it's in our court, it's likely to be in every court in the country, including criminal procedures, where there are separate problems raised, as you know, judges, juries, witnesses, and so forth. A second problem is, will understanding be promoted if you can, because you can only show the oral argument, which is 1% of what goes on. And people relate to what they see much more than what they relate to what's in writing. And we're deciding cases that we have results for 300 million people, and only 6 of them are in front of us. And we have to worry a lot about what our ruling will do to the 299,999,000, et cetera, that aren't there. And so will there be misunderstanding about that? And the third, which I think is minor, but it's possibly there. It's not that the lawyers and judges or anybody would act up. I don't think they really would. We just had the Canadians in a visit to us, and they have it in their Supreme Court, and it's worked out all right. But there's some concern about we have a group of people in our press room who know how the court works. And when you read what they say, you know it's being written about by someone who knows how the court works. Now, that isn't always so. The cameras don't always have the time. And will there be misperception given? Now, you can take those 3 worries I've listed and say in your own mind, they don't stack up against the plus. I can understand that. But our jobs are those of trustees for this institution that served America well. And there is no going back. I think there is no such thing as an experiment on this in the Supreme Court. You have to decide it. And that's why I think what's needed is a comfort level that by giving a comfort level, it may come sooner rather than what I tend to agree with you on, inevitably later. Now, how to get that comfort level is a long, complicated matter. I've always said it will involve studies, and serious studies, not just ones promoted by the press. Serious studies of what's happened in different places. And when I say that, everyone goes to sleep, because if you mention the word study, that's a good somnorific. But I think something like that's necessary. That's why I like these pilot programs, even in other courts. I think there are things to be learned, and I think eventually we'll get the comfort level, but I think we're not there yet.
Just if I can engage a little bit on that, because, I think you mentioned three different points, probably the most substantial being that, people could misunderstand because the case only ostensibly applies to the litigants in the court, but it affects millions. There's, in my view, far greater chance of misunderstanding if the public isn't able to see. There's far greater, I think, opportunity for people to be suspicious of the outcome or misunderstand the process or misapprehend the process. They don't have the window into the court's workings that would be provided by actually watching. And so your first observation, I think, is the much more compelling one, which is it would be beneficial to the court because people would understand what it does better. It would be beneficial to the public to gain that understanding. And I think that clearly trumps any risk of misunderstanding, which is always going to be present, and I think is more present when things are done less visibly than with more visibility. Is that the tapping of the gavel?
The 9-minute gavel, yes.
Okay. I'll wrap up, Mr. Chairman. Thank you. I knew I should have made the comment about the Red Sox. I also think that the kind of slippery slope point that if you do it in the appellate courts, you must do it in the trial courts isn't necessarily so. And there are different factors at work when you have a jury and when you don't. And finally, the fact that the print media may be very good and very professional and you have less control with the electronic media, that's true in our profession as well. A lot of what we do is in writing. A lot of what all government bodies do is in writing. And I don't find that a compelling reason not to go forward. At the end of the day, I think you put your finger out and you said, we just have to decide. And I don't think a study is going to give you a comfort level. I think the only thing that's going to give you a comfort level is by taking the plunge. And I also think, Justice, this is just inevitable. And if it is inevitable, we might as well plunge forward. And I appreciate the Chairman's indulgence. Thank you, Mr. Chairman.
Thank you. The gentleman brings up an interesting issue, one that the chairman, since his days in the State Assembly, has dealt with, about court cameras in the courtroom. My concern, just on the record, is one that will probably get me badly spoken of tonight on some talk shows, but it's precisely the fact that both on the left and on the right, there will be evening talk shows, not the news, but the talk shows, grabbing clips from that day's Supreme Court proceedings and saying, did you hear Breyer? What a jerk. Did you hear what question he asked? Did you hear Thomas? Oh, my God. Jesus.
No, he didn't hear me.
Did you see them there? You know?
Yeah, there you go.
And that's my concern. And, I'm sure that, the desire for full disclosure, people are going to say tonight that, what am I for covering things up? But I wish there was a way that we could let the public see more and not just invite people to treat the court the way they treat us.
Well, there is a difference. Can I?
Sure.
I mean, and sometimes it's overlooked, but I think it's an important one in the nature of the jobs. When your job is to write some words on a piece of paper, and those words tell people what to do or what not to do. But they don't tell on that paper. They don't say why you wrote the words. That's not the nature of the job. So obviously there's an inside story that's not on that paper. A judge's job is different. A good appellate judge The ideal is you write not just the words, you write the reasons why you wrote the words. And if you're honest and good, they explain the real reasons why you wrote the words. So in that sense, the process is quite different. And it's a process that does take place much more in writing and much less even in conversation among us than, say, a job like yours. So they are different. But I can see your concern there, and of course it's something that worries us.
Sharon, if I could just jump in one quick point.
You're on Mr. Crenshaw. He is not happy. Go ahead. Go ahead.
Mr. Crenshaw is such a gentleman, he'll allow me 30 seconds, please. No one is suggesting that your job is the same as ours. But I am suggesting that the public would benefit from a better understanding of your job just as it benefits from a better understanding of ours. People watch your arguments and listen to your arguments because they find the questions that you ask shed light on sometimes your own thinking, shed light on the issues in the case. I think the more the public has a chance to see how thoughtful and probing those questions are, I think, as your original comments indicated, it's good for the court and it's good for the public. And I yield back, Mr. Chairman.
Mr. Crenshaw.
Well, thank you, Mr. Chairman. I might make the observation that today's hearing is being televised, and one thing is irrefutable. When you put members of Congress on television, they tend to talk longer than they do when they're not on television. So I don't know if that's true to the Supreme Court, but we've kind of seen that over the